All right, guys, welcome back to the channel. So first and foremost, here's a little background. So this morning I wake up and I'm going through my phone and I'm looking at all these different posts, things like that. And I come across a post from Cameron Atkinson, who is a lawyer here in Connecticut dealing with civil rights, mainly the Second Amendment as of late. Now, he gave a ruling from yesterday on the 30th of September. And I read what he wrote and I was like, what court case is he talking about? And that's what we're here to discuss today. All right, guys, before we get too far into it, I just want to remind you guys down in the description below is a link to the merch store. It's a great way to support the channel. You can also become a member here on YouTube, Patreon, or Locals. And at the very least, which doesn't cost you a dime, simply liking this video, throwing in a comment, which will benefit you in the end. And if you haven't already, subscribe to the channel, toggle that notification bell to ensure you always get an update when I put up a new video, a short, or we go live, usually on a Saturday night, because leaving the comments is really important. Currently, we are giving away this pink Glock grip for the Glock 17, Glock 19X, the Glock 34, Glock 45 from GlockGrip.com. Included in this, obviously, is going to be Save a Pop. Included with that grip will be a patch that says, Save the Pup, Abolish the ATF. And I am throwing in a Strike Club sticker right there. Ask me down in the comment section about the first rule of Strike Club. So get into the comment section, guys. Comment on this video, on the case we're about to discuss, and you will put yourself in for a drawing for that giveaway. D70 Racing already sent his off, sent it off a couple of days ago. He should be getting it tomorrow. So, guys, it pays to play. All right, let's get into the statement that I saw. First and foremost, Cameron writes, statement on September 30th, decision in the Nastri v. Dykes case. Now, I have no idea what this case is about. So I read on. This decision authorizes total firearm bans in any public space that the government deems too crowded. The logic would have justified banning firearms on the Lexington Green, April 19th, 1775, that precisely what the Second Amendment prohibits. Any attempt to spin this decision as a win for public safety is pompous puffery that is an insult to every law-abiding gun owner and the Constitution itself. We will appeal this decision in the Second Circuit and, if necessary, the U.S. Supreme Court. Lastly, we recognize that Judge Bolden did what he thought the Second Circuit required him to do. We obviously strongly disagree, but in an age where the judges constantly get threats, we emphasize that we have great respect for Judge Bolden as a judge, including for his approach to this case. So what case are they talking about? So we know that the answer from the courts is that they can ban firearms and carrying of firearms in any place they deem too crowded. So, what are they talking about? Here we go. You may or may not know that in the state of Connecticut, you are not allowed to carry a firearm in state parks. So if you want to go to Sleeping Giant, you want to go to Devil's Hop Yard, Hammonasset, Great Neck Beach, any of our state parks, then you cannot have a firearm with you. Now, it does kind of make sense at the beach. What are you going to do? Just leave it on the beach when you go swimming? Where it doesn't make any sense is in state parks when we go hiking. Because, you know, there's bears and bobcats and weirdos all out there on the trails, and you're all out there on your own. Maybe you have a hiking buddy. But again, you are just set up to be a victim at this point. So the case, I found it online, and I will always, of course, put the links for these cases down in the description below so you can find it and read it for yourself. David Nastri appeals from a judgment of the district court dismissing the lack of standing on the claim alleging that 28 U.S.C. 1983, that Connecticut's ban on carrying firearms in state parks violates the Second and 14th Amendment of the United States Constitution. Specifically, Nastri argues that the district court erred in concluding the lack of standing to bring a pre-enforcement challenge to the regulation. Connecticut Agency Regulation, subsection 23-4-1C, because he could not show credible threat that Connecticut, the state of Connecticut, would enforce the law against him. We assume the party's familiarity with the facts and procedural history and issues on appeal. I like that. I think that's quite humorous, because I do remember a couple of years ago, somebody called 911 in Cheshire dealing with Sleeping Giant, saying that they thought they saw somebody with a firearm. Now, how did the police respond? Well, that's pretty easy. Deep Cheshire PD and I think a few other agents showed up and shut the parking lot down, trapping people inside. And then they hunted this person down on the trail. That is enforcement. So saying that they won't enforce it, I find it hard to believe. We review de novo a district court's decision to dismiss the complaint for lack of standing. See Rajaman and Deutsche Bank National, and it goes on and on and on. The plaintiff bears the burden of establishing standing under Article 3, and it lists a bunch of court cases. To do so, the plaintiff must show a sufficient causal connection between the injury and the conduct complained of, and a likelihood that the injury will be redressed by a favorable decision. That's Susan B. Anthony List v. another case. Courts apply a distinctive rule to decide whether a plaintiff has standing to challenge the constitutionality of a law before it has been enforced against him. In these pre-enforcement challenges, the plaintiff must show that the threatened enforcement of the law against him is sufficiently imminent. The imminence showing requires the plaintiff to demonstrate that he or she intends to engage in a course of conduct that arguably involves a constitutional interest. His indeed conduct is prescribed by the challenge of law. There exists a credible threat that he would be prosecuted for violating this law, and it goes on and on and on. The parties do not dispute that Nastri has established the first two imminence elements in that he alleged an intent to carry a handgun in a state park for self-defense in violation of Section 23-4-1C. Thus, the central issue in the appeal is whether Nastri has demonstrated a credible threat that he would be cited for violating this section if he were to engage in that conduct. Since the district court's ruling in this case, we had occasions to clarify the standard for a credible threat of enforcement, and that's the Antioch case. Another case involving pre-enforcement challenges to state firearm laws under the Second Amendment. All right, guys, so I'm not just going to sit here and read this whole thing. I want to give you guys the highlights. Again, I will have this link down below. But something that I found interesting is, finally, the state suggests that the law at issue is moribund, and thus not likely to be enforced because Section 23-4-1C has origins dating back to 1918. Guys, I guarantee you, right here the state is suggesting we're not really going to enforce this, and you can't prove that we would enforce it. I guarantee you that if you were to go hiking and carry your gun with you and something went wrong and you had to use your firearm in self-defense, whether it be against some stranger, a bear, a bobcat, anything, I guarantee you the state would enforce this law to the fullest extent that it could and would make you the poster child of why we don't carry firearms in state parks. And I'm really sick and tired of when the state passes a new law and then we come up with some sort of lawsuit to challenge said law. Their defense is always, well, there's no guarantee that we'll actually enforce it until they do. They did this when we asked for an injunction with Grant v. Lamont, dealing with our assault weapons, the assault weapon, basically the AR-15 ban, the Connecticut other ban. They came out and the state literally was like, Well, there's no guarantee that, or no proof that we're actually going to enforce these. So our injunction was denied because the state's like, well, prove that we'll actually do this. Well, they're doing it to Heather out in Plymouth. And again, she has her next court visit on October 22nd. And as soon as I know something, I will bring you guys an update. So as it stands right now, yes, you still cannot carry a firearm into a state park. Now, I would never recommend going hiking in a state park with a gun. All right, that you do you, boo. Me personally, I avoid those places like the bubonic plague. Now, places where we can carry and hike, we're going to use that for an example. So basically all federal parks. Now remember, the federal park building itself is off limits. However, all the federal park trails are available to you to hike while armed, except in Connecticut, because if that federal park is also state property, then it is illegal for you to also then carry your firearm. Thus, it's a moot point here in Connecticut. But like I've told you guys in the past, and I tell my students all the time, when Mrs. Guru and I were down in the Smoky Mountain National Park in Tennessee, we went around the park, hiking, things like that, armed. Because there's critters out there and there's weirdos. And anywhere you can carry, you should carry. That being said, there is another update I want to tell you guys about. It just broke here a little bit ago, and I got to pull it up. All right, real quick. Today, guys, a federal court on Tuesday ruled that the federal ban on firearm possession, storage, and carrying at U.S. post offices violates the Second Amendment. Chief District Judge Reed O'Connor for the U.S. District Court in Northern District of Texas this week handed down a 17-page ruling on the case. Two citizens of the Lone Star State who desire to carry their firearms for self-defense while visiting the post office, but refrain from doing so out of fear of violating federal law. O'Connor in 07, appointed by a federal bench by President George W. Bush, pointed out that the Postal Service ban doesn't square with history and tradition. Oh, can't read. So the article goes on. I will pin the article down in the description below. For now, the court is ordering the blocking of the USPS from enforcing its no guns policy, and it covers, not you, but who does it cover? It covers the two plaintiffs involved with this and the organization to which they are members. So this would be the Firearms Policy Coalition and the Second Amendment Foundation, because both of these pro-gun groups are behind the lawsuit. So everybody that's a member of FPC or SAF, you guys, well, you're protected. Okay? It's been vacated. Now, we have our own lawsuit coming out of Connecticut. Cameron Atkinson is actually doing that lawsuit too. So we'll see where ours goes. But right now, out of Texas, the two individuals involved with this case and FPC members and Second Amendment Foundation members are covered. It's vacated for them. So technically, if you're a member of one of them, you can carry into your post office. Now, it does tell you what kind of post office is. So what kind of post office? It limits you to specifics. Okay? It is limited to the standalone post office and does not cover USPS property on military bases or inside larger federal buildings, such as the U.S. Courthouse, which has its own post office. Separate laws that prevent the carry of firearms apply there. But your standalone little podunk post office, vacated. Again, the two defendants and FPC, SAF members only. If you are just a run-of-the-mill person, the law still applies to you. So now we know that the federal government more than likely is going to appeal this, or the post office is going to appeal it, and it's going to go up to the Supreme Court, who may or may not hear it. But it's only the Supreme Court that can lay down the law of the land for everybody. This decision coming out of a district court out of Texas will only affect a small individual, because we've already ruled, or the courts have already ruled, that mass injunctions are unconstitutional. You can't do that. You can't just do a sweep across the entire country as just some tiny little judge in a tiny little town somewhere, which is what a lot of these liberal judges have been doing, trying to block the Trump administration from implementing their policies that the American people voted for. Thus, the Supreme Court said you cannot do blanket injunctions. The Supreme Court says you cannot do blanket injunctions for everybody that is not involved in the case, unless it is a class action lawsuit. And this case right here is not a class action lawsuit. So we'll keep our eye on it, and when I know something, you'll know something. That's pretty much all I have for you guys today. I wanted to cover a little known court case that was going on, dealing specifically here in Connecticut and our state parks. And then while I was reading the lawsuits and the decision, all that good stuff, this did pop about the post offices, so I figured I'd throw that in here and bring it to you. So that's all I got for you guys in this video. I will see you all later.